Hello, business owners, and welcome to another episode of Don't Skip the Legal, the podcast where we unravel the legal complexities of your business world to empower you for success. I'm your host, Andrew Contiguglia, your corporate casual business attorney based here in Denver, Colorado, with nearly 3 decades of legal experience. Today, we're delving into a significant legal development that is making waves in the business landscape. That's right. It is the Corporate Transparency Act. And if you haven't heard about it, this is the podcast for you to listen to. So grab your favorite beverage, kick back, and let's get started. I'm Andy Contiguglia, your corporate casual Denver-based business attorney, bringing you the Don't Skip the Legal podcast, where you can listen in on the real stories, the real stakes, and the real legal lessons from real business owners just like you. These behind-the-door conversations about business are instrumental to your success. This is where the deals are made, negotiations are discussed, and company problems are identified, leading you to overcoming the challenges we all face in our business. This podcast is your invitation to where the real business happens, and also where the best ideas take place. So let's get behind the doors in business and break down these legal lessons. And overall, remember, don't skip the legal. In early 2021, Congress introduced the Corporate Transparency Act as part of the Anti-Money Laundering Act of 2020, and it signaled a paradigm shift in how businesses disclose crucial information. And its primary goal, to enhance transparency and combat financial crimes like money laundering and terrorism financing. But as a business owner, you might be wondering, how does this impact my business, and why should I care? Well, my fellow business owners, the Corporate Transparency Act mandates non-exempt business entities, referred to as reporting companies, to report specific personal information about their beneficial owners to FinCEN, the Financial Crimes Enforcement Network within the U.S. Treasury Department. This reported beneficial ownership information is then securely stored in a non-public database, which is managed by FinCEN. The rules implementing the reporting requirements kicked in this year, January 1st, 2024, marking a pivotal moment for businesses across the nation. So why is this significant, and how will it affect your day-to-day business operation? Let's dive in a little bit deeper into the nuances of this reporting requirement. The Corporate Transparency Act represents a crucial step toward creating a more transparent business environment by requiring reporting companies to disclose the individuals who ultimately own or control a company. These people are known as beneficial owners, and the Act aims to build trust, ensure accountability, and safeguard against illicit financial transactions. Now that we've set the stage, let's dive into the specifics of reporting deadlines and the timeframes under the CTA. As the implementation of the final rules went into effect on January 1st, 2024, understanding these timelines is still very crucial for businesses aiming to stay compliant. And as you'll learn later on in this podcast, failure to stay compliant can result in huge civil penalties and possibly even criminal charges. First and foremost, reporting companies formed before January 1st, 2024 have a key deadline on the horizon. They are required to submit their beneficial ownership information to FinCEN no later than December 31st, 2024. This marks a significant milestone and sets the stage for a new era of transparency in business operations. Now, for those companies formed on or after January 1st, 2024, there is a 90-day window. This time frame, adjusted from the original 30 days after receipt of your notice or of your filing of the starting of your company, allows these entities to submit both beneficial ownership information and a company applicant information to FinCEN. It is essential for businesses to understand and meet these deadlines to avoid penalties and ensure compliance. So simplified is this: if your company was in existence before January 1st, 2024, you have until the end of 2024, December 31st, to file your beneficial ownership interest with FinCEN. If you started your company, if you started your business after January 1st, 2024, you have an obligation to get your FinCEN and your BOI, your beneficial ownership interest, filed with FinCEN within 90 days of when you started your company. So now what we're looking at is companies, as we do these formations and LLC formations, corporation formations, what we're looking at now, including your articles of organization or your articles of incorporation, we are now looking to add this layer of registration along with all the other registrations that you should be doing along with your company. So it's important to take note that these deadlines are not just arbitrary dates on a calendar. These are critical checkpoints that the Corporate Transparency Act has put in place to ensure a timely and comprehensive reporting process. Understanding and meeting these deadlines is not only a legal requirement, but a proactive step toward maintaining the integrity of your business operations. Failure to do so, as I have mentioned, can result in civil penalties as well as possible criminal charges against you for failure to comply. So as businesses prepare to navigate these timelines, it's essential to stay informed, mark these dates on your compliance calendar, and be ready to take the necessary steps to meet the reporting requirements. Compliance isn't just about checking the boxes. It's about embracing transparency and accountability within your business structure. Now, keep in mind, not every company is required to report under the Corporate Transparency Act. Now, we're getting into the little nitty-gritty of what defines a reporting company, and I'm going to talk a little bit about the 23 exemptions provided by the Act. There are 23 exemptions under the CTA for businesses that are not required to file under the Corporate Transparency Act. These are from large operating companies to publicly traded entities. So understanding these exemptions is key to navigating compliance. So what exactly constitutes a reporting company? Under the CTA, a reporting company is any entity created by the filing of a document with the Secretary of State or similar office under the laws of a state or Indian tribe. It can also include entities formed under the laws of a foreign country that are registered to do business in the United States by filing a document with a Secretary of State or a similar office under the laws of a state or an Indian tribe. Now, the key here is that reporting companies are not exempt from the reporting requirements. Now, let's talk about the exemptions. The exemptions under the CTA are crucial to understanding who may be exempted from these reporting obligations. So the CTA includes 23 exemptions offering relief in certain types of entities. So let's look at some of these exemptions and take this opportunity sort of to provide a little clearer picture about what we're looking at. So if you are a securities reporting issuer, all right, these are entities involved in securities reporting. These entities are exempt. If you're a governmental authority, the governmental entities, these are not subjected to reporting requirements. If you are a bank and a credit union, traditional financial institutions, banks and credit unions, these traditional financial institutions, they are exempt. Depository institution holding companies, these companies, any company involving in depository institutions, they are excluded. Money service businesses, so entities engaged in money services, these businesses are exempt. Broker or dealers in securities, so securities brokers, dealers, these fall under the exemption. Securities exchange or clearing agencies, these entities operate in securities exchange, they are exempt. All right, so these are just a few examples of exemptions outlined in the CTA. Large operating companies, certain tax-exempt entities, publicly traded companies, various financial entities, all of these fall under the exemptions under the CTA. So it's crucial to understand as a business owner where you fall into these categories. And if you're already regulated by the government, good chance that you fall into one of the 23 exemptions that the CTA calls into question. So thoroughly review the exemptions along with your legal counsel, determine if you qualify and if you can navigate a path around the reporting requirements. Otherwise, you're going to be obligated to report. So understand that these exemptions, these are likely to change too. So keep in mind that as this CTA grows and as the regulations sort of, grow and develop and legal challenges are made, you can see the regulations are likely to change. The nature of your company could also change. So you could start off as an exempt company under the regulation, but then later change, or the nature of your business could change in which you might lose your exemption requirements. So think of a large operating company that initially qualifies for an exemption, but then later loses it because it fails to meet the exemption requirement. So make sure you stay informed, stay on top of everything relative to your business for these changes and understanding the specific criteria for each exemption as it relates to your company. This is imperative to your CTA requirements. Now let's talk about who must be disclosed. These people are your beneficial owners. According to the Corporate Transparency Act, a beneficial owner is any natural person who, directly or indirectly, either exercises substantial control over a reporting company or owns or controls at least 25% of the ownership interest of the reporting company. These individuals are required to be disclosed under the CTA. Now, what does substantial control mean? An individual is considered to have substantial control if they, let's talk about that, serve as a senior officer, holding a position or exercising the authority of a CEO, the president, the CFO, general counsel, COO, any other officer with similar function. So basically anyone who has authority over the appointment or removal of any senior officer or a majority of the board of directors. As you evaluate your company, not only do you need to look at who owns at least 25% of the ownership interest in your reporting company, you need to look at the people who have substantial control. So these individuals who have the authority over the appointment or removal of any senior officer. Again, these are your high-level executives. And if you have a big board of directors, all these people are going to be required to be disclosed as beneficial ownership interests, a BOI, because they have substantial control within the company. So determine who in your company has these obligations. So you're looking at your owners, who owns 25% or more, and you're looking at those who are sort of in executive management of the company as well. So by bringing this transparency to the individuals who significantly impact a reporting company's decisions and operations, this really is the core importance of the CTA. So not just the top-tier executive, but those who wield substantial influence behind the scenes. So you really need to critically evaluate this information. Now, if you were coming to me and you had a question about it, or it sort of sat on the line or on the fence about whether somebody was or was not to be included as a beneficial ownership or who has substantial control, there's nothing hurting you to overindulge on the information. It's only when you fail to indulge the information to the government that you're going to get in trouble. If you overindulge it, there's nothing wrong with that. And keep in mind, all this information is going into a sealed, quiet government database. Now, you can run whatever conspiracy theories you want in terms of gathering information that the government is keeping an eye on everybody, but that's kind of what they're trying to do here. Think in mind, people who own or control at least 25% of the ownership interest of a reporting company, these are beneficial owners. The ownership interest is broad. It encompasses equity, stock, capital, profit interests, convertible instruments, options, or any other mechanism used to establish ownership. And it's important to note certain exclusions from the definition of a beneficial owner as well. These includes minors, like children under the age of 18, not pickaxe in hand, individuals acting as nominees or custodians, and employees whose substantial control is solely derived from their employment status, provided that they are not senior officers. So just because you're a manager in the company or you exercise control over a group of people as a manager, that doesn't necessarily put you into executive management. So you need to sort of evaluate your employment status in that case. That's a good question that you could be talking to your lawyer about. All right, now let's switch our focus to the company applicants, because if you formed your company post January 1st, 2024, the Corporate Transparency Act requires information about the company applicants for entities formed after that date. So if you hire somebody to create your company, like a law firm or some other company, those company applicants or anybody applying for the exemption, those people are required to be disclosed as well. So any company applicant, these people include those who directly file the documents creating the entity, so like your LLC, your articles of organization for an LLC, your articles of incorporation for a corporation, partnership agreements, anything that you're filing with the Secretary of State, those individuals, those domestic reporting companies are required to be included in your BOI disclosure. Or anyone who registers the entity to do business in the United States if it's a foreign reporting company. So this also includes the individuals directly responsible for controlling the filings. So if you were to hire me to file all of your corporate paperwork and start your company, I would be required not only to file who the owners are as a BOI with the CTA, but I would be required to disclose myself as well as the individual who is responsible for directing or controlling the filing. So in this particular case, to dig into that a little bit deeper, a company applicant could be your lawyer, a paralegal, an employee at the business formation service that assists you in the formation of your entity. So if you're using a company like LegalZoom, if you're using some other corporate assistance company, And doing it online, those individuals might be required. So FinCEN requires up to 2 individuals to report as the company applicants, even if more individuals meet the definition. So it's important to emphasize that the company applicant reporting requirement only applies to new companies formed on or after January 1st, 2024. If your company was in existence prior to January 1st, 2024, all you need to do is register, but it's not required that you file the company applicant information as well. So any entity formed before this date, those companies are not required to report the company applicants. So what happens if you don't comply? This is always the question, like, oh my God, I forgot to do this. What's going to happen to me? So listen, the compliance is real and the consequences are real. And the government is out to make sure that everybody does this. So the CTA is going to look at penalizing you, civil penalties for failure to comply. And if there is willful noncompliance or willfully providing false information or failing to report accurate details, those civil penalties can be hefty. And any criminal penalties, also including imprisonment, can also take place. So understanding these civil penalties, any possible imprisonment, understanding these stakes is crucial for your business and for the leaders within your organization. So the CTA holds businesses accountable for providing accurate and timely information. So it is unlawful for any person to willfully provide false or fraudulent beneficial ownership information or to willfully fail to report, complete, or update beneficial ownership interest. So if you made a mistake and forgot or didn't know, they're not going to really nail you for that. But if you knew it and you willfully avoided it, you're looking at an investigation. You're also looking at possible penalties. So what are these penalties for noncompliance? Let me break it down a little bit for you. The Act provides for both civil and criminal penalties depending on the severity of the violation. So first, let's talk about these civil penalties. A person found in violation may face a civil penalty of up to $500 per day. And this penalty accrues for each day that the violation continues. These civil penalties can add up quickly, emphasizing the importance of a timely and accurate reporting. So if your obligation was to, let's say you started your business January 1st, 2024, you file all your articles and everything. You have now 90 days. So you have roughly till the end of March to get your BOI information done. Let's say you wait, you're impatient, or you're not impatient, but you sort of wait, you lag around a little bit, and now here it is April 1st and you forget and you don't do it. You could be penalized $500 per day, every day, April 1st, April 2nd, April 3rd. That's going to add up quickly. If you're doing it on purpose and you're trying to hide information about your company, well, let's take a moment to acknowledge the importance of legal knowledge in the business world. Legal issues can be a minefield, but they don't have to be. That's why I am thrilled to introduce you to a resource that will be your guiding light through these challenges. Get ready to discover the ultimate legal companion for entrepreneurs. I am excited to introduce you to Don't Skip the Legal, the startup guide for entrepreneurs and business owners, your ultimate companion for conquering the legal challenges of entrepreneurship. It is authored by me, Andy Contiguglia, a seasoned business lawyer based here in Denver, Colorado. This book is your roadmap to navigating the legal landscape with confidence. Inside, you'll find valuable insights on choosing the right business entity, understanding fiduciary duties, tackling financing options, hiring employees, and even nailing down the perfect business name and location. But that's not all. You can get your hands on this essential guide in both Kindle and paperback form, making it super convenient for you. If you're ready to empower your business with knowledge, head over to Amazon, head over to Kindle, and grab your copy of Don't Skip the Legal today. For more details and updates, visit don'tskipthelegal.com, and don't let the legal hold you back in succeeding in business. With Don't Skip the Legal, the startup guide for entrepreneurs and business owners, you can take your business to new heights. Available on Amazon and Kindle. Now let's get back to the pod. Guess what? That's going to be a problem for you too, because in that case where you are willfully avoiding the obligation, that could result in criminal penalties against you. Let's talk about the criminal side. A person who willfully fails to report, complete, or update your beneficial ownership information may face fines of not more than $10,000 and or imprisonment for up to 2 years. That's a pretty big deal for missing a deadline. Understand and make note that these penalties should not be taken lightly. It's not like they're going to say, oh, well, don't worry about it. It's going to happen, and you're going to see people happening. Now, that's also going to create legal challenges and things like that moving forward, and there's always, the whole emphasis of dealing with lawyers and trying to work out a resolution. So do understand and don't devalue the seriousness of the reporting requirements. So senior officers of any entity failing to file a required beneficial ownership interest, these individuals are the ones who could be held accountable for that failure. So the CTA emphasizes the responsibility of leadership in ensuring compliance from that leadership and within the organization for these new reporting requirements. So leadership, it's on your back. Make sure you keep this in line. But what happens if there is a genuine mistake or a need to correct the information? Well, the nice thing here is the Act does provide a safe harbor provision from penalties for those who voluntarily submit a reporting or correcting inaccurate information within 90 days of the deadline for the original report. So if you're filing your information at the end of March 2024 because you're a new company, started at the beginning of the year, and you put in wrong information or you forgot somebody's information, you go, oh my God, I talked to Andy Contiguglia, he told me I missed some things, now I got to add it. Guess what? That safe harbor provision is probably going to allow you to sort of sneak by so you can correct it because you're not doing it intentionally, you're doing it just because you forgot. So the importance of prompt correction is also something that you need to take into consideration just in case you create errors or you forget something along the way. Now, if you are involved in intentional misrepresentation or the providing of false or fraudulent beneficial ownership information, that carries significant risks. That's where your criminal penalties are going to be involved. So it's not just about ensuring compliance, but also about maintaining the integrity of the information that is provided to the Financial Crime Enforcement Network, or FinCEN. So what are some practical tips and considerations you can take as you delve into 2024 with your business and compliance under the Corporate Transparency Act? So I'm not just here to lay down the law for you. I want to be able to provide you with actionable insights. I want to be able to give you this information and give you some ideas so you can think about what you can do to make sure that your business stays compliant. So let's discuss some practical tips and considerations for your business as you navigate the Corporate Transparency Act. So these things really range from internal processes to staying informed about the exemptions. So let's explore some strategies that you can have. First and foremost, the electronic filing is the name of the game. As of January 1st, 2024, businesses must file their BOI reports electronically using FinCEN's secure filing system. Literally, it is FINCEN.gov. It is FinCEN.gov, and that is where you go. It is a form you fill out online. I did it for my companies. It took less than 15 minutes per entity, something really short and sweet that you can do. So embrace the digital shift here. Ensure that your systems are ready. Familiarize yourself with a really user-friendly platform that is provided by FinCEN. As for your timing, if your company was formed or registered before January 1st, 2024, mark December 31st, 2024 on your calendar. This will be the deadline for filing your initial BOI report. For those established on or after January 1st, 2024, you need to act quickly. You have 90 days after receiving notice of your company's creation or registration to submit your initial BOI report. Also, stay informed. Explore FinCEN's dedicated resource at www.fincen.gov/BOI. At that website, you'll find comprehensive information, guidance materials, and frequently asked questions. Don't hesitate to reach out to FinCEN directly through their contact page at www.fincen.gov/contact if you have specific inquiries. So knowledge is your ally in this journey. They really are trying to make this available and easy for everybody, so there's no excuses that you can't get it done. As I said, I have done it. I've done it a couple times for clients. It is really very simple. Internally, create an internal compliance calendar. Mark the important deadlines, including the initial filing and any subsequent updates on your calendar. This ensures that your business stays ahead of the curve, and it minimizes the risk of unintentional non-compliance. And always, make sure you collaborate with your favorite lawyer, Andrew Contiguglia. The Corporate Transparency Act introduces a new layer of complexity. So seeking legal advice from your legal counsel can be instrumental in navigating this terrain. So ensure that your legal team is well versed in the nuances of the act and providing you with tailored guidance so you don't make mistakes in the reporting process. And last, review compliance not just as an obligation, but as an opportunity to enhance transparency and trust. Embrace the opportunity to enhance your business operations and reinforce to your community your accountability. So what does the future hold? Under the CTA, who knows? So let's take a look here. Let's look at our crystal ball. Let's discuss potential implications and predictions. What might happen coming up down the line? So how is this business landscape really going to evolve, and what should businesses prepare for in the upcoming years? So I really anticipate sort of this shift in corporate governance. The Corporate Transparency Act really marks a significant departure from traditional business practices by introducing these really unprecedented transparency into the ownership structures of reporting companies. This shift may prompt businesses to reevaluate their governance models, place a renewed emphasis on accountability and their ethical practices. So as the reporting requirements become more ingrained in businesses' operations, I think we're going to see an evolution in compliance strategies as well. Businesses are likely to invest in compliance framework. They are looking to leverage technology and legal expertise to streamline the reporting process. The Act's digital filing mandate may also pave the way for advancement in secure electronic reporting systems. So that's great. On the legal front, I'm predicting really an uptick in litigation surrounding compliance issues. As businesses grapple with the intricacies of beneficial ownership reporting, legal disputes are going to arise because this is new. There are going to be legal challenges to who should report, whether somebody willfully did it, whether somebody did it by accident. All right, so these cases where we have interpretations of who maintains substantial control or ownership interests, when these become contested, that is going to create legal issues. So this, I believe, is really going to lead to a body of case law that further refines the Act's application. But that's what lawyers do. We challenge the laws, we put it to the courts, we try to get information and context to what the law is supposed to mean. In addition, I think you're going to see a change in the global business landscape. This Corporate Transparency Act right now is just in the United States, but I think you're going to see a ripple effect as the CTA sets precedent for enhanced transparency worldwide. I think this is going to influence international discussions on beneficial ownership reporting standards, potentially inspiring other jurisdictions like Europe, Asia, South America to adopt similar measures. I think there's a worldwide interest in combating money laundering, not financing terrorism. So you're going to see other countries, I think Canada, Mexico, all of these other countries enacting similar legislation to provide for, similar disclosures, to keep an eye on everything. And they're going to end up sharing all this information with all the other countries around the world. So this is going to be an interesting and a difficult process for criminal organizations around the world to be able to navigate. They're going to be required to register everywhere they go. So in the realm of business transactions, I'm anticipating an increased emphasis on really due diligence. As stakeholders become more informed about the ownership structures of reporting companies, mergers, acquisitions, partnerships, these are all going to undergo a more rigorous vetting process. So part of our due diligence process in M&A work, we're going to be evaluating all of this information, who the BOIs are, who's embedded in making the strategic decisions for the company. This is going to reshape how businesses approach negotiations, their risk assessments, really as they look into things in their corporate arena. And last, I think the Corporate Transparency Act really serves as a catalyst for ongoing conversations about privacy, security, and this real delicate balance between transparency and individual rights. As reporting becomes the norm, society may grapple with questions about the appropriate boundaries between corporate transparency and personal privacy. And I think this is going to spark discussions that extend beyond the legal realm. I'm sure there are plenty of you out there going like, what? Now I have to disclose all this information to the government? The government doesn't have a right to understand or know what I own and all these different things. Well, that is sort of where we are going as a society and as a business society to really struggle with these questions. What are the boundaries? If we give the government this much lead, how much more are they going to take later on down the line? But again, now you got to look at the legal issues surrounding that and how it all integrates together. So the future implications of the CTA are really, I think, pretty broad, and they are multifaceted. So from transforming corporate governance to influencing global standards, I think the legislation sets the stage for a new era of transparency and accountability. So as businesses adapt to these changes, it's important to stay informed and proactive. I think that's going to be the key to navigating this new and evolving legal landscape. So I want to leave you with some closing thoughts on the Corporate Transparency Act. So whether you're a seasoned business owner or just starting, staying informed and proactive, I think, is the key to navigating these changes successfully. Remember, knowledge is your greatest asset in the legal landscape. First and foremost, compliance is not just a legal requirement, it's a strategic imperative. The CTA represents a paradigm shift in how businesses disclose their ownership structures, and embracing compliance isn't merely about avoiding penalties. It's an opportunity to showcase transparency, build trust, and fortify the foundation of your business operations. The Act's impact extends beyond legal obligations. It's a catalyst for change in corporate governance. It urges businesses to reassess how they structure and disclose their ownership interests. So as we move forward, I think the business landscape may witness a transformation with a heightened focus on accountability and ethical business practices. So for businesses, navigating the reporting requirements demands a proactive approach, investing in robust compliance frameworks, leveraging technology for efficient electronic filing, and signaling and seeking legal counsel who will be instrumental in ensuring a seamless transition into the new era of transparency. The Corporate Transparency Act isn't just a law. It's a catalyst for change. It's a response to evolving societal expectations and a step toward a more accountable business environment. So stay informed, stay compliant, and remember that understanding the implications of today's legal landscape shapes the future of your business. So thank you for joining me on this deep dive into the Corporate Transparency Act. If you found this episode today insightful, don't forget to subscribe, rate, and leave a review. Your feedback fuels our legal journey. And until next time, remember, I'm Andrew Contiguglia, reminding you to don't skip the legal. Knowledge is power. Good luck. Thank you for listening to the Don't Skip the Legal podcast. I'm your host, Andy Contiguglia. I hope you enjoyed our time together and this great opportunity to peek behind the business door and examine the legal lessons in business. If you're keen to hear how these lessons can be applied in the real world, well, join us next week for another episode where you can listen in to another business success story. As always, you can head over to contiguglia.com/podcast to sign up to our email list, as well as check out all the links and resources in our show notes. If you enjoyed this episode and you'd like to help support the podcast, please share it with others, post about it on social media, or leave a rating and review. To catch all the latest from me, you can follow me on Instagram, Twitter, and TikTok at AJCESQ. Thanks again. This is Andy Contiguglia reminding you to don't skip the legal. Good luck. The legal information contained in this podcast is intended for general informational and entertainment purposes only. It should only be used as a starting point for addressing your specific legal issue. The legal information I talk about does not create an attorney-client relationship between you and me. This podcast is not a substitute for an in-person or telephonic consultation with a lawyer who is licensed to practice in your jurisdiction about your specific legal issue, and you should not rely on this legal information for those purposes. You understand that questions and answers or other information contained in this podcast are not confidential and are not subject to attorney-client privilege. I am not providing you a legal service. Every legal case is different, and past performance is not indicative of future results. Please consult your own attorney.